May I have lordships kindly to mention a matter, my lord.
Aste.
Extension of interim order. I'm sorry, my lord. Interim order ending, my lord, in the end of May. So any day next week convenient to lordship. I am grateful.
My lord, may I permitted to mention two matters for inclusion in the list.
Under what heading?
Read, my lord. Read petition, my lord, for new motion and neighbor.
New motion.
Yes, my lord.
State is a party.
My lord.
Have you served the state?
My lord, I have served.
Not earlier, after the change of panel.
No, my lord.
Please don't mention now. Please let the new panel be formed. Please serve a copy. Otherwise, no use including those.
My lord.
Please serve a copy. Then give a notice that he will be mentioning. Thereafter mention.
May I get your lordship's kind leave to mention one matter. Move urgently, your lordship. Read petition. BLRO has warned us, threatened us to demolish the property, and the date is today, your lordship. Today they are coming with all the things to demolish our property, your lordship.
When the notice was served?
Your lordship, no notice was given, your lordship. Only the verbal communication was done, and even we have written to the police. The police is not accepting any complaint, your lordship. They are saying it's BLRO matter. Unless and until there is an order of the court, we cannot interfere. Your lordship, I'm just praying for some accommodation, your lordship, so that my premises could be saved, your lordship. After that, your lordship, they would come and depose before your lordship.
Someone from the state.
Your lordship, state is a party. If your lordship would say,
have you served the state? Who is appearing for the state?
I'm just moving it urgently, your lordship. Leave to file.
Leave to file. Do about a সময় রাখুন.
Contempt application.
To serve
upon the any advocate
appearing for the state, your lordship. Appearing for the state, your lordship. Due to the panel and all, your lordship.
Then what can be done?
Your lordship,
to know everything.
Your lordship, kindly an order may be passed so that your lordship, at least some accommodation, your lordship.
Serve a notice upon Mr. Trivedi along with a copy. Ask him to come.
Gratefully, your lordship.
Yes.
Contempt application.
Yes.
I have mentioned it for non-prosecution.
For non-prosecution, you have a written instructions.
Yes, written instruction. There out of 6 petitioners, one had expired in 2016. No one came up for substitution. The remaining others have signed. The death certificate as well as the communication, both are here.
The learned advocate appearing in the light of the submissions made by the learned advocate for the petition. Yes, next. Number 2. Yes, you Lord. করছে নাকি হ্যাঁ
Item number 3, I am for the petitioner, my lord. Your lordship, concerning order page 2, my lord. Only the typical mistake, 16 December, in place of has been written.
Representation dated 16 December 2025.
My lord. On the middleman had been taken 16 February 2010.
16 February.
Only the 5 line of the second para of your lordship orders.
Please see, come to page 25 of the writ petition.
16 December.
Then
This is the 16 February matter has been written. Middle of the matter.
no, in the order it is 16th December. Your representation also says 16 December.
My lord, the order has been in the middle of the order sheet under second page has been written 16 February 2065. It's the 25. The middle of the order,
Oh,
five
middle.
line. Middle of the 5 line, my lord.
Acha. It has been pointed out that in the that in the sixth
I have taken instruction. Well, firstly, I don't know if after that I checked up, it's only to show cause. The hearing will happen. So no eviction decree will be passed on Monday. So, well, that's
can postpone it after.
with much persuasion, Lordship, I'll have to tell my Lordship. Lordship kindly sees there page 5. Only this
Page
is
5
page 5
of the writ petition.
of the writ petition, page 5. Lordship kindly takes a look at that, paragraph 9.
Yes.
Paragraph 9, page 5, came to be challenged, so and so, so and so. Kindly come to the 6th line. Your petitioner had approached the land manager of Kolkata Port Trust through a letter 26th April expressing that the firm was prepared to pay rent under protest provided an order is passed securing refund of the amount. And now this is also recorded in their letter at page 24 that they're willing to pay the rent under protest without,
If the claim of the because they want
if it is
refund,
secured, so that,
claim of the state is upheld.
yes, so,
That's the
and
vesting.
yes, and now they have repeated that again.
What
This
do
is
you want?
yeah, so let them pay this. Lordship will provide that in case they don't, in case the states succeeds, then it will be refunded. And Lordship keeps it sometime in June. I will not give any
What do you
affidavit.
say to this? It's your stand also.
Right. No, we had
And
been
I've-
trying to get this reply from them since 2019.
I couldn't get it, so I want my lord to give that order.
It was
Now,
not
not-
taken
yes,
instructions.
not in the notice of eviction, there is a reference to alleged dues from 1983 to 2019, which is not correct. Can't be. If your lordship will kindly have a look at page 33.
Page.
33.
No, Mr. Mojumdar, what according to you is the due?
Not there may be, not in my, according to
What
my,
is your admitted amount?
yes, not there may be a due of 36 months in 2 or 3 phases because of the orders passed by the court interim order.
36 months. What is the quantum?
Not kindly,
Right,
not in
right.
the, on an earlier occasion.
Lordship kindly sees page
36
45.
installments were
Their
paid
letter,
We'll come
their
back.
last letter on
36
March. They've given how many months?
ordered from the date of, there was an earlier
Page.
Page 45. This is the March letter they've given. According to them, they have not paid for this period.
According
Kindly
to us,
come to the
36 months is the due in 2 or 3
the
phases.
6th line of page 45. 6th line. Resultantly for a short term from January 19 to March 22 and from December 23 onwards. So around 36 by 36, 72 months.
That's what I'm saying. In
Whatever,
2 phases,
let-
36 or 37 months could be due in 2 or 3 phases.
but to whatever is this period
Whatever
they
it is. Not,
mentioned,
So this from January 29 to March 2022
and
and from December
December 23
23 onwards
onwards
till this date.
yes, yes.
till
So you deposit that amount.
No. This
And
one-time
Mr.
deposit,
Mitro
one-time
says that
deposit will be a hardship. One-time deposit will be a hardship since we had been trying from 2019.
all right.
But on an earlier occasion, the court
What will be the amount?
The amount is 28 lakhs according
more or
to
less
us.
28 lakhs.
28 lakhs.
More or less
28 lakhs.
Not we go on making payment not of the monthly rent. Not in so far as the arrears are concerned, that I would be requesting for certain installments to be granted. On an earlier occasion, the court had granted 36 installments. I leave it to your lordships.
Mr. Mojumdar, at least to show some bona fide
That's right. Not
for the time,
not
how
from
much
2019, I had been
I
trying
ask
to
you as an
resolve.
officer of the court, how much according to you would be the reasonable amount which you,
The current we shall go.
some amount you put in within
And also keeps it in June. No opposition required. There's nothing in this application. I will get it. Or you fix it in June. Kind.
and you will be protected, Mr. Mitro
Yes,
says, refund will
Lordship's
be,
order will provide that.
yes. Sir, Mojumdar, I tell you, be reasonable in court.
Yes. No, that is what I am not uttering what she says. No, I am very careful.
Yes. That is why I stopped you before quoting that figure.
Stay.
Uh, 28 lakhs and odd. So as per your
As of today,
statement
it
in
could be
paragraph
30 lakhs.
45.
As of today, it could be 30 lakhs. Because of 1 month's rent has fallen due.
Mr. Mojumdar,
as a businessman that I get refund with the statutory rate of interest.
That's there.
For the
but
time being,
some sort of some
the
interest you
principal,
are
the
liable
principal.
to pay.
This is
principal.
statutory only here. We don't have a
Well,
choice.
it's
not-
from 1983.
No,
So
it's
some,
not 2019, it's only from 2019.
all right.
It's a misnomer.
Even if
It's
it
a-
is
Oh,
from
there was
20
delayed payment
even
then.
if it is from 2019, you are liable to pay some interest.
Not that's,
So it's
No, I-
not that the entire interest.
I had been writing to them that during the period of vesting, do I get back the money if I pay it to you? They had not been responding, so they were also not
You
sure.
can't
Without
put a-
Be that
prejudice
as it
also,
you can't put a
under
condition.
protest, without prejudice also, you could have
Paid.
done that.
But,
Mr. Majumdar,
taking back the money from government is in extreme possible. No, I know it for the provident fund authorities, the employees even don't get back. Forget the employers.
But they will have to pay rent to somebody. So this is
No, it's
not that.
whether they are. No, I am not going into the merit of the case. What is the
Right.
effect of vesting or all these
doing one
things?
thing, I'm keeping it on June.
Why not?
So do one thing, you deposit 10 lakhs within,
Second week of June.
no,
First week
10
of June.
10 lakhs within May 29
I'll also get fix
And
the date for
the-
hearing.
and 5 lakhs on or before the next date of hearing, which I will be fixing.
Another.
Another 5 lakhs because 1383 according to you is the principal.
That's the principle.
So you cannot say
Plus
that some no
Very-
interest you are liable to pay. So I'm directing you not saying anything about the principal and interest. This is the
Lump
amount-
sum.
lump sum for the present. কি বললাম? Yes. না, 17 তারিখে মোশনই রেখে দাও। Motion.
Lordship, I am for the
Mr. Mojumdar and Mr. Mitso, please, 1 minute. So, I've passed an interim order in your presence. But yesterday I was told in one matter, Mr. Bhattacharya said that at times some objections are being raised if a matter is order is effective, order is passed under the heading to be mentioned.
No, Lordship,
No,
Lordship.
So I will record
But
it,
heading not it.
From my side, it was there would
but
be.
I'm told somewhere up this.
Yes,
No,
yes,
no, no.
I know. There has been some observation. I have.
That is why,
What?
though this matter is appearing under
There
the
is
heading,
no bar that
No, no, no,
court
ठीक है.
cannot pass an
Recall,
but,
order.
Mr.
kindly
Mojumdar,
record that.
yesterday I was told that
Kindly record that.
You have been learning this from the day one.
No. Can you record that because I have also seen this
Because-
happening.
that is what both of them understood. So, with though this matter is Yes, 5.
in item
I am for
number
the petitioner, your lordship.
in item number
I am
5.
not parties. Not if it is not served, parties to act on the basis of communication.
Yes, I think
Mr. Mitro is there. but-
there.
Yes, yes.
The Mitro is there. I don't think it will be a problem. Mr. Mitro, please, he says that if please the estate officer will act on the basis of the communication of the parties. Please communicate. You know? Yes,
Lordship,
you are for the
I-
private respondent.
Yes, Lordship. On the
State.
last occasions, the direction upon the Lordship respondent state that to submit the report. So far, my instruction is concerned, Lordship, that demarcation that has been completed by the Lordship BLR Road, I
It
know
has been
2.
completed.
Yes, Lordship.
Lordship in last.
We have called for your Lordship by issuing notice by the Lordship BLRO and in presence of the party of the writ petition, in this writ petitions,
So what is your instruction? Demarcation has been carried out.
Lordship, demarcation has been carried out, your lordship, but as per last direction, your lordship, that is issuing prior notice to the petitioner and private respondent and any other person who may be affected by such demarcation, your lordship. But the BLR only giving notice to the petitioner and private respondent, no
Are
other.
you canvassing the case of any other third party?
No, lordship, but
Then let them come.
look,
It
lordship,
seems that you are trying to bring in some other interested parties. I've
lordship.
given them to protect others' interest. You are not canvassing their case.
Lordship, actually, there are not a specific boundary of that PWD land, your lordship, and there are
Differently.
others.
So,
Okay, lordship. Lordship.
the learned advocate appearing for the panel is prepared.
Lordship.
Yes. Next.
Item 6, my lord, I am appearing for the petitioner, my lord. First of all, my lord, due to change of panel services are not complete, my lord. And secondly, my lord, the matter relating to my lord group 9, it is my lord our mistake that the matter has been listed wrongly, my lord, before the group 1, my lord. I am for the petition.
Group
Suman-
9.
My lord, it's pertain to group 9, non-police. Suman Kollan Chaudhary, matter name, my lord.
But you have mentioned this as group 1.
Yes, my lord, that is mistake of our, yes, my lord, that is mistake of our clerk, my lord. I'm paying apology for that, my lord. A service is also not complete, my lord.
Learned advocate appearing for the petitioners. Yes, next.
My lord, one thing, my lord, one thing, my lord. Since the my lord appearing date is today, my lord, and we have not served, my lord, kindly pass in, my lord, online, my lord, order that in the meantime I will serve, my lord, upon the
That is
state, my lord, kindly, my lord. Otherwise,
you can
this,
serve.
my lord, otherwise, my lord,
I do not
otherwise,
have
my lord,
determination.
we,
I do not have determination. After that, I cannot pass any order. You have indicated it's without jurisdiction. I cannot pass any form order,
yes,
excepting
my lord, because, my lord, the Sarthak, my
yes.
lord, okay,
Without direction also you can serve, sir. There's no difficulty. Yes, call the next matter.
7 and 8 are the same matters arising out of same dispute, but whether it will ultimately be a sweet ending or a sweaty ending would depend on, my lord, both clients sitting together, of which they have evinced an intention. Now, my lord, if your lordship is so
What is this
pleased,
matter?
this is a Bancharam shop in Salt Lake, which was being carried out as a by a licensee, Mr. Banerjee's client.
Essentially, landlord-tenant
And,
dispute
no,
regarding the shop.
it's a
Trying to have this
licensee.
settled with both the Banerjees are getting.
Now,
Kindly
so-
keep it on
so we
Tuesday, my
hope
lord.
that it will be sweet at the end.
Hopeful that
There is a
at the
very high
intervention
chance.
of both Banerjees.
Banerjee sweet will prevail and sweat will not. But in the event is the reverse, this Banerjee won't
I'm
mind.
keeping it after the vacation.
No, no,
But
your lordship
kindly
keeps
keep
it
it on Tuesday. It's simmering. To bring it to a boil, please keep it on Tuesday. Let it retain
Tuesday,
its
lordship
position.
keeps it.
I perhaps
We'll
not by
probably
that
be
time.
able to
One big
finish
dispute,
it off
my
that.
lord.
But without the state, can it be taken
Yes,
up?
Mr. Dheeraj Trivedi was acting as
We-
amicus curiae. He is there.
That's right.
I've
Yes,
spoken
where
to
is
Mr.
Mr.
Trivedi.
Trivedi?
I've spoken with him. He was there.
Like before court room number 2, Your Honor.
He'll be
Today is
there
on
on
like
Tuesday.
Tuesday, your lordship will kindly.
We
keep it.
spoken.
Ashun. Mr. Arindam Banerjee and Mr. Shuddha Sattva Banerjee appearing for the respective petitioners. Yes, please ask Mr. Trivedi to take instructions because in case it fails
Yes.
and in case it is settled, please intimate Mr.
We leave
Trivedi
it so that he's rid of all that.
yes,
We'll do.
otherwise
Yes.
Great.
yes. Under the same heading, he could
Yes. On the same heading, let it retain its position, my lord. Kindly.
My lord. 9 also, my lord, Mr. Trivedi was appointed yesterday, Your Honor.
yes.
My lord, he is on his leg before court room number 2. My lord,
I'm
is short.
asking you to ask him to come because I require his presence. Please ask him to come. Yes, item number 9, passed by Mr. Jha, please. Please ask him to come after he finishes that. Yes.
For application note that tender where not QPT 6 to
Yes, what-
disburse the sale proceeds of the property to one Warsi traders.
Yes, Mr. Nag was here. Where is he?
Well, he's just on his way, my lord. I mean, led by Mr. Shubhankar Nag. He's just on his way.
He's on his way.
Yes, ma'am.
All right. Yes.
This will immediately come back to your lordship's mind if you would kindly turn to page 92.
Yes.
But the tender is at page, yes, 92.
Many senior advocates for the petitioner, it shows that there is no merit in this matter.
Kindly do not come to that conclusion. We are beneficiaries of this. When Mr. Mujumdar is there, the burden
This is
is
what those observations we heard. I heard when I was there.
I can come without any tension.
As you are concerned, but court gets another impression.
E-tender under two-part system, part 1, techno-commercial bid and part 2, price bid for allotment of land at Hyde Road. A for R, Mrs. Warsi Corporation.
What happened? The financial bid has been opened.
Well, the bid is still live, it's still alive. It's alive till 21st May.
It has now been extended. Now,
Till 21st of May.
May, the bid is alive.
Numbered only one.
What instruction I got, my lord?
So if I keep it after the vacation with the same understanding,
Yes.
what's the difficulty, Mr. Nag?
No, nothing. But I just want to, my lord, take two things, my lord, that this writ petition, my lord, I said on an earlier occasion that, my lord, they are a disputed question of fact.
After vacation,
And-
yes, after vacation.
So that I will consider.
After
but
vacation.
with the same order, if I can extend this,
Yes.
I'm keeping it just after the vacation.
In the meantime, if we can use an affidavit, some facts I need to, because there are suppression of facts
Already.
that I want to bring on record.
You can file an affidavit that regard.
Not only thing, not the tender is not to be
So this-
finalized.
I'm restraining you. This time is extended 20th of May. Restrain from that is till the last order. Ashun.
Not only one thing, not a supplementary affidavit to bring those facts.
What facts?
Not one fact is not with regard to QPT claiming that it
You are
is what is.
expanding the scope of.
No. Only with regard to the tender.
Yes,
tender.
The in all matters you are filing supplementary
Yes.
affidavit. This shows that when it was filed, you were not consulted.
Yes, not even settled.
That usually happens.
On the prayer of
respondent was served because
Mr. Mojumdar, did you serve
because
the
the
private
issue-
respondent? If it was service
on
by-
last occasion it fell from your lordship. That is a private dispute between two in respect of the structure.
Mr. Mojumdar, do one thing. No one is appearing for the private respondent.
I don't think.
Please intimate the date of hearing.
They
to
are
the-
taken care of. The private respondent is well taken care of.
Yes.
But you also, by abundant caution, you, if a service filed in court today is taken on record. In spite of service, none appears.
Mr. Sen is right. And on the last occasion, your lordship had restrained the private respondent from being disbursed with the sale proceeds of the,
Yes,
of
yes.
the value of the properties. Now, my lord, what Mr. Nag spelled out on the last occasion, what happens if Warsi becomes successful? He will have to deposit the money with QPT.
Yes.
Now, my lord, if that amount be deposited, but let this amount remains in a separate account. Whatever amount Warsi deposits.
That can be taken care of. If that will be on record, the orders will be passed with regard to that.
Sorry, sir. May I just?
Yes, yes.
Advantage can be taken off by Warsi. They will say, I am not required to deposit this amount because
There is a
amount is to be
restraint.
paid
Let
to
them
me.
let him come with that stand, then I will consider. Now
But
it's
then
only
they,
thing.
they
Only
should not declare Warsi as the successful.
No. It cannot be
without
done. Then I have to
depositing
argue.
let them let the auction take place thereafter because the matter is pending. Any steps
normally
taken?
Your lordship will kindly say this thing, my lord, that Warsi will have to be no one should be declared as successful.
Let that happen.
In
Anything.
respect of, because
when
then
it-
what happens when he
No, my lord.
gets an unfair
He is
advantage
asking for
without
modification of
depositing.
interim order.
But when it
case
comes
is
to
not here,
when it
Mr.
comes to
Sen,
rent,
let that. If you make out that case, I will consider.
but
that.
when it comes to rent, QPT is not too eager to have this money. When it comes to sale proceeds, QPT does not want to receive money.
Why is QPT opposing this? Well, this is not
All right. I will consider that. Yes. Yes. Thing cannot be immediately after because it has to be on 22nd তো সেটা তো ইন্ট্রিম অর্ডারটা তাহলে লিস্ট দিস ম্যাটার অন 22nd of June 22nd of June করে দিন তাহলে ইমিডিয়েটলি আফটার না ওটা ইমিডিয়েটলি কথাটা উড়িয়ে দিন আফটার দি এত করে দিন
ওইটা বলে দিন
ওটা হলে কনফিউশন হবে
এবার গিয়ে বলবে যে আমি সব
yes
I apologize, Miller, the matter.
that is there your junior was here
Yes,
but
but
I
I
declare your presence
no,
Mr.
Miller,
Trivedi.
I've come, Miller,
That
because
is
this
why
will
I
not take
asked you.
much time. But therefore, I've come, Miller, because
Have you taken instructions?
my lord, I have taken what has happened, Miller. I could take instructions from the police authorities. They have given the entire documents as to how they have got the property. My lords may have a
That is the writ of possession.
writ of possession and everything. Lordship,
Only thing what is troubling me is that Mr. Jha's client purchased a property. Now there is a deed. Now the deed records that at one point of time the property stood vested. Thereafter, by an order, it stood divested. Then Mr. Jha's vendor purchased it from the original person on whose account this vesting was made. So he purchased. Thereafter, he transferred to Mr. Jha's client. So that is the way how Mr. Jha's client is claiming title in respect of this property. Now, but the fact remains, one important fact is that I do not know, no record of rights has been annexed in whose name it is appearing. He has, according to him, he has applied for mutating his name in the record of rights, but that has not yet happened anything. Nothing, neither rejection nor allying,
May I say
nothing.
may I say one thing? Pursuant to making the application for recording my name, there was an instruction from the BLRO to make an application for a long-term settlement. This is why this
I will speak
came.
to that. I will come. So, rightly or wrongly, no order either rejecting or allying his prayer for mutation has been effected. Now, what happened in the meantime, his client applied for long-term settlement. before the authorities. You know the consequences. Long-term settlement can be only in respect of a vested property. Mr. Jha's contest submission is that was done through mistake, because I could not have paid for long-term settlement on my property since I am the owner of that property. Now, these are the facts. Now, what happened is, writ of possession has been issued in favor of the police department by the block land and land reforms officer. Now, if the property is a Rayati property, if Mr. Jha has the title, the BLRO could not have issued a writ of possession without initiating any proceedings for acquisition, requisition, anything. That could not have happened. Now, the other thing is, if that property is still vested, then you could have. Now, the problem is the police authorities, they have constructed a boundary wall encircling that property. Mr. Jha says construction is going on. So I want instructions on that, whether it's still vested, what is the record of rights? Because if he is the owner, if there is nothing, because the special land acquisition officer has filed a report. I think you have been sub with a copy of the report. He says no acquisition proceedings. That will not be done, because if it is vested, there cannot be any acquisition. In that way, though Mr. Jha said two reports are contradictory stands taken, but I don't see that, because unless maybe the special land acquisition officer was right by saying it has not been acquired. Even if it is vested, there is no question of acquisition. But if it is his property, then without acquisition, nothing can be done. So one thing is admitted, there is no acquisition. The other thing which is very vital, whether that vesting order still remains or it has been set aside.
The ULC says there is no vesting.
ULC is vesting under ULC, not under.
There are a number of laws under which vesting takes place.
So ULC, there may not be any vesting, but there may be vesting under these provisions of the Estate Acquisition Act. So that ULC cannot take care of that. So this is the situation. Now he is paying for an interim order restraining him from making further construction, because none of the reports have said anything with regard to the vesting. Only document, I think, unless you have any further instructions, except the writ of possession, he is having a title deed. And title deed, it's not a question of suppression. Please see his title deed once. Because this fact has been, because I have got to know this fact from his title deed also. So it's not that there is a suppression. Page 18.
I've gone through it.
It stood vested, thereafter preferred an appeal, and there is an order. Free from. So if no further vesting took place, then he has the title over the property.
Milord, what I am, Milord, as far as I could contact the police has got all the documents. As far as BLRO is concerned, Milord, I contacted them, but Milord, I could not get the right person, because, and I also spoke to the erstwhile advocate, Mr. Wasim Ahmed, who was appearing in the matter. He gave me these documents and the number. Now, Milord, two things from but I have to consult the BLRO.
Yes, that is
otherwise he is the person, because who has given it. Because Milord,
only
they are also
that whether there is any vesting. If there is any vesting by any under any statute, then unless that is set aside, nothing can be done. That's one aspect. If there is no further vesting after it has been divested, then he has the title. He cannot take away his property.
I totally bow down to whatever is falling, and that was what I was trying to understand from my learned senior friend, Milord. What is happening, Milord? It is like something like two wrongs, and we are trying to make one right. He doesn't have the document, the document which has been registered, which has been stated in the deed at page 18,
yes.
Order number 33, he doesn't have. He doesn't have any mutation, even that in whose name the property is recorded.
That is why
I am also in the dark, because the BLRO is not. And now, Milord, if I concede, Milord, then Milord, let there be an interim order, Milord, in this stage, Milord, it will become.
Don't carry out any further construction. Encircling of the property has been made. Please don't carry out any further construction. When can you come back? This side of the vacation.
My lord, if I suffer an interim order this side of the vacation, because then I'll be carrying a burden of an interim order.
There are two things.
My lord,
why you will be spending from the public exchequer.
My lord.
So why you will be wasting money if you do not have any title or any right to carry on with that construction. That is what is, and Mr. Jha is running, I think, from the month of April.
My lord, I can.
Every day he
can.
is running,
I can.
and yesterday he said, "I am running. I am
The
not."
biggest problem, my lord, which I am facing is that we at this stage, my lord, we don't even have a nodal officer from whatever my reference is, the police officers.
So police cannot say this because they
My
have.
lord, they are not saying. I am trying to get numbers from them, and when I am calling this land department people, my lord, they are very laid back. My lord, will not take us a miss. If you call them, okay, tomorrow. I also told them, I gave them my designation, then they started working, but then they are trying to find out if my lord so deems fit and proper, my lord. I am just, my lord may record my submission that police report is with me, my lord, and I could we could not contact the concerned
Block
BLR.
land
Yes,
reforms.
Lord.
Yes, I am recording
So
that.
recording that, so under those circumstances, in the meantime, my lord will restrain.
Yes, and when can you come back?
My lord, if my lord, it will,
Wednesday?
yes. Wednesday.
Wednesday,
Yes,
please
sir.
see,
Yes, sir.
please take, please collect the record of rights in whose name it was.
And
there.
my lord will kindly not extend, grant the interim order. Will surely grant the interim order beyond Wednesday, my lord. But this side of the vacation, my lord, I will be there.
No, I will keep it because unless for any reason, Mr. Trivedi, only what is troubling is if you cannot get any instructions by
Yes, sir.
Wednesday, I will keep it on Wednesday. I'm passing an interim order.
My
I
lord,
think after
my
the
lord,
vacation.
my lord.
If it is vacated, it is vacated on that day. Otherwise, after Wednesday, there is no time to take up.
My lord, I bow down.
That is why
It's very practical, my lord. Actually. Because I am trying to join issue as a state, but my lord, if I see the practicality, my lord,
no, I have appointed you as the state for the learned advocate for the
my
state.
lord, as a my lord.
No. Not as an amicus curiae. I think I have appointed you as the
My
advocate.
lord, whatever false.
Once things are,
I've
once
also
things are
directed the
regularized.
your I think your
No,
appointment to be
senior.
regularized. I think
Your lordship has passed order to that effect regarding
Yes.
regularization.
to regularization along with a junior
Along
of
with
your
a junior.
choice. I have said you can
My
take
lord,
your
now the panel, there's no.
junior is
My
here.
lord,
because
none of them are in the central panel.
So by this,
All my juniors, my lord, none of them are in central panel. They are all my chamber juniors who assist me.
maybe Mr. Trivedi in a particular matter you can take him.
Yes, my lord, I can. But I will not take. I will take someone. My lord will kindly not. My lord, I am here to assist your lordship.
Trivedi, he has appeared yesterday also. He is today also he
My
appeared.
lord, they are
you
trained
should
to
get
do
a
that
chance in the panel.
because my lord, what happens is, as soon I was in the Union of India, my lord, I have these 4 freshers from college, 4 juniors, and now they have been trained in such a manner and they have been doing it. So, my lord, that is because if I can get the chance to get them in the panel, it's okay. Otherwise, I'm great. My lord, may I take my lord's leave because that Tiljala demolition matter is going on?
Yes.
My lord,
So I'm keeping it on Wednesday.
Yes, my lord.
So you take instructions from the
Lordship.
block land and land reforms officer, and in the meantime, I am restraining you from carrying out any further construction.
I'm grateful.
Mr. Trivedi, learned advocate, appears Yes, next. Yes.
Lord, I have collected other two judgment of the apex court.
Lordship, they would have given me yesterday so that I can distinguish it. I mean, anyway, Lordship, I will stick to only the Article 226, and I also refer some judgment, Lordship. That
Let him place if you want some time to consider that. Yes.
Lord, the apex court held that after completion of the pleadings, when the matter is ripe for final hearing, the court cannot relegate the matter to other forum, my lord, on the ground of technical ground of jurisdiction, because the matter my lord, was ripe for final hearing. Because in the writ court they did not initial stage they did not take any point of territorial jurisdiction.
Sir, have you found out any judgment on Article 226?
My lord, it is
Sir, here is the question. Because 226 jurisdiction is limited within the territories of that state. Can a writ be issued outside the state?
But my lord,
please, have you got a decision on Article 226? It's a well settled proposition what you are saying. Once alternative forum, if there's an alternative forum, if the matter is taken up, yes, after some time, it cannot be relegated to. These are well settled proposition. I'm asking you, have you found out any decision on Article 226 which says yes, a writ can be issued beyond their territories also?
On this specific point, my lord,
we are concerned on Article 226 only.
Because I collected
because 226 is very specific.
Court, in this case, Supreme Court consider.
There are a large number of decisions on the jurisdiction under Article 226. Cause of action part also. I'm telling you, there's a decision of the Supreme Court where it says in disciplinary proceedings, entire thing happened outside. Now, before the appellate authority, when he preferred an appeal, in the meantime, he returned to the state of West Bengal. So apex court decision, but it went from the state of West Bengal. He filed that appeal through post from his residence at within the state of West Bengal. The hearing notice was sent to his residential address. So it was sought to be argued that a part of the cause of action arose within the state of West Bengal. Supreme Court negated that. No. That's not giving rise to a cause of action. That is why Section 21 CPC is fine. I'm asking you whether you have got any decision on Article 226.
No, at this stage, my lord.
Yes.
Lordship, if I
have you got a decision on Article 226?
Yes, Lordship. Before I go into that, Lordship, that if I read the Article 226 for once more, Lordship, that power of High Court to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, order, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose. The Lordship, I will stick to this only. Now, Lordship, may kindly.
You will not place 226.2.
Lordship, that is also, but this itself, Lordship, that kind.
226.2,
Yes.
please place that.
The power conferred by Clause 1 to issue directions, order, or writs to any government authority or person may also exercised by any High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Now, Lordship,
if the authority is situated outside, writ can be issued from this. That's sub rule 226.2 2 says it clarifies that. That is why I asked you to place. This will be against you. When you read an article, you
But
have to
Lordship,
read
that
it in its whole. That's the way you interpret,
Lordship,
not only one part of the Article 226.
no, Lordship.
226 says within its territories, 226(2) says, yes, beyond territories can be granted, but provided a part of cause of action
Here,
arises within.
yes, that is but the part of cause of action.
That's,
Here, Lordship,
that is why I told him.
but
so even if
not a partial part of cause of action arises in this jurisdiction, not Lordship.
show me a decision on that.
Lordship. And Lordship, one more thing before going to that, Lordship, my judgments, Lordship. Kindly, I also distinguish the Lordship judgment preferred by yesterday, Lordship, by my learned.
Please show your decisions, thereafter you will distinguish.
Here, Lordship, in the judgment, Lordship, it was regarding the section 47 and 21 of the Civil Procedure Code, Lordship. This is not related to Article 226, Lordship. Anyway, Lordship, and that's
That's why I told him.
Lordship.
Have you got any decision on Article 226? But we have adopted the Code of Civil Procedure in our rules.
But article
as far as practicable, we have adopted.
No, but that is for the procedure, Lordship. But the regarding that applicability of the Lordship, Article 226 is very clear, Lordship, in that.
Yes, then.
Reference to 2004 6
Yes,
SCC
Kusum ingots.
6 SCC 256. Page 28 254. So here I will directly come to the paragraph 28, Lordship.
Yes, this is what I am saying. Paragraph 13, ONGC, that went from Calcutta. ONGC. Paragraph 13 of this decision. ONGC versus Utpal Kumar Basu. That went from Calcutta.
Yes, Lordship. So this considered, and Lordship, that also in the final paragraph 28 onwards, Lordship, it clarifies the position, Lordship.
Do you have this decision?
ONGC
1994 4 SCC 711.
No, Lordship, I am not carrying that, Lordship. I'll refer another two judgment also in the same notes, Lordship, that whether.
Yes, which paragraph you are relying
Lordship,
upon?
page paragraph 28 onwards, Lordship.
Paragraph
28 onwards, Lordship.
Yes. Sir, you have seen this paragraph 29 and 30. Paragraph 29 and 30 clarifies that of this decision.
And most importantly, Lordship, that yesterday the judgment referred by my senior colleague, Lordship.
You have any other judgment? No.
No, Lordship, I have another judgment.
Yes.
Lordship, I have marked it. Kindly pardon me for that.
It will help me.
Yeah, Lordship, paragraph 12 onwards. 2008 3 SCC 456, page 456. 456. Territorial jurisdiction, Lordship, did dealt by this judgment.
Yes, this is on disciplinary proceedings.
Yes, Lordship. So there are other judgments also, Lordship. There are lots of judgment on this issue, Lordship. In all judgments, Lordship, it is categorically decided that
And in all judgments, ONGC versus Utpal Kumar
is
Prasad
referred, Lordship. Yes.
referred to. That's the parent decision.
No judgment otherwise, Lordship. There is decided by Honorable Supreme Court as well as any High Court also that beyond the territorial jurisdiction, Article 226 can be exercised, Lordship. This was recorded. And one
Yes.
Lordship, one more judgment, Lordship, your Lordship, and kindly consider. This is old judgment, Lordship, 1989, 2 SCC 162. 163. It's paragraph 20, 21 onwards, Lordship.
Paragraph 20 and 21.
Yes, 21, 22. Here it is, Lordship, observed that even jurisdiction cannot be ousted by the parties.
That's the agreement by way of an agreement.
Yes, that is also considered. That even that cannot be also considered. So old judgment. Well, and also clarifies the Lordship cause of action also. In the paragraph 12, what would be the cause of action? That also clarifies by the Honorable Supreme Court.
Yes.
And also this is not their case that Lordship that partly or any cause of action arises within the jurisdiction of this Honorable Court, Lordship. That is not disputed. That is admitted that cause of action is out of the jurisdiction. And in our affidavit in opposition, we have also submitted that, Lordship. It was altogether his record showing that he was the resident of, Lordship, state of Bihar.
Yes. Anything more?
And Lordship, that judgment they referred yesterday, that is no way relevant to in the present case, Lordship, because that in my respectful submission, Lordship.
Yes.
Lordship, that it was that Lordship article section 47 and 21 jurisdiction and objection to jurisdiction, Lordship, and that went to up to the High Court under Article 227. It was deciding by the Honorable High Court, Lordship. There it was decided that jurisdiction should have been the point of jurisdiction should have been taken in the first place. After subsequently it cannot be done. But here, Lordship, it is the case is it is the read jurisdiction of the Honorable High Court and directly invoked by the Lordship, the Honorable High Court. It is not that, Lordship, it was preferred from the trial court or that jurisdiction which was not taken in the trial court, that point or like that, Lordship.
Yes, sir.
It is no way relevant to in our present case.
Anything on these decisions? Will you submit today or you will consider and come back? Will you make submissions today on these judgments or you will consider and come back?
My lord, I shall consider and come back.
Heard the learned Yes. I'm coming after 5 minutes.
Your Lordship, I am appearing for the petition, Your Lordship.
Yes, have you informed the state?
Yes, Your Lordship, I have informed Mr. Dheeraj Trivedi, Your Lordship,
Yes.
and he was about to appear.
Where is he?
Your Lord, may kindly inform once to his junior.
Yes, call the next matter. Item number 12. Yes.
I am for the petitioner, my lord. The alleged contemner, my lord, lost in the trial court in connection with the eviction suit, first appellate court and second appellate court, all forum, my lord, he lost. Thereafter, execution proceeding was initiated, file application under section 47, that was rejected. Against that, my lord, he preferred application under 227. My lord, the petitioner defendant paid for time for 6 months. My lord, your lordship granted time to vacate by February 2026, subject to production of the undertaking. The first undertaking was wrong, that was not accepted.
Then undertaking was filed.
Undertaking was filed, my lord. First undertaking was wrong, therefore second undertaking.
Now what happened?
Now, my lord, he did not vacate. February 2026 was the last date for his vacating.
Is directed to serve. Yes, call the next matter. Item number 30.
Then, Mirror Lordship, last occasion on 10th April, Lordship has passed an order to impeach some other parties against whom I am seeking the order for implementation of removal of encroachments. The state was directed to file reports.
State is not here, but
Yes,
can be done.
that's right. And also, my affidavit of service for addition of party is not prepared. May I
I
come
did after that.
after
Yes,
vacation?
pass over next.
After vacation? After vacation?
After vacation.
After vacation.
On the prayer.
My lord, I am for the petitioner, lordship. Lordship.
Pass over next.
After that.
15.
15, I am for the respondent number 6.
Yes, next.
17, my lord, I am appearing for the private respondent, my lord.
State is not here.
My lord.
Pass over next.
22 and 24.
22, I am for the respondent.
State is not there.
Corporation.
Pursuant to your lordship direction, we try to serve the copy of this
22 and 24.
Yes,
24 as also 27.
In 22 and 24, my lord, matters may be kept.
24. After vacation, 22, 24 after vacation.
My lord, I am appearing on behalf of the petitioner in this matter. Along with Mr. Samar, kindly keep it on 10th or 11th June.
No, after vacation, it will appear thereafter. Yes, next.
In the same heading, my lord, kindly please.
Yes, next.
But under the same heading.
Yes, next.
25, 26, 7.
I am appearing on behalf of the petitioner in this matter.
27 after vacation, next.
27 after vacation.
28, 29, 30, 31, 32, 33, 34, 35,
35.
Yes, your lordship.
35 is Eastern Coalfields.
Yes, yes.
Yes.
What I appear
Who is for the Eastern Coalfields?
But Eastern Coalfields Limited, the filed
File
the
the
report. But kindly
35.
take out my application. And your lordship will be astonished. What type of jugglery they are playing before with the court. Lordship,
Mr. Banerjee, who is appearing
that's
for
right,
Eastern Coalfields?
appearing, Lord, Mr. Sushant Pal and Pradipto Basu. As it appears from your lordship's order dated 24th April 2026.
Sushant Pal and Pradipto Basu.
My lord.
So where are they?
But I do not know, my lord. They are avoiding because if your lordship kindly take out my application reformed on 11th of May 2025.
Yes, what is the writ petition about?
Writ petition about Lord Eastern Coalfields has taken out my land by forcibly by my lord using my lord the payloader.
State is also a party, Mr.
My
Banerjee.
lord.
State is also a party.
State because I made complaint, but nothing has been done. But lordship kindly see their report. See their report.
Whose report?
Report is the Eastern Coalfields Limited.
Eastern Coalfields Limited has filed a report.
No. Copy has been served 11th of May.
They have not filed any report before the court.
11th of May. Lord, it has been served, my lord,
But
to
no
me.
copy has been filed in the court.
Your lordship may fix, but kindly see the report.
What does the report say?
Kindly
What
see.
is the stand in the report?
Nothing has been prescribed, my lord, regarding my claim because I am the writ petitioner. But the lands which are my lord belonging in the name of my daughter, but they are ready to register it and rest, my lord, is pending for approval and it will be registered very soon. Last line of the, my lord, the report, second or third page. Lordship, kindly pardon me for this. But lordship, kindly see, they are saying that we are not cooperating with the registration.
So you are the owner of these plots, 520 by 582.
There are 528 and there are other lands over the same plots. That is not my plot. I am the writ petitioner, and my daughter plots is adjacent. But so far as the daughter's plots is concerned, they are ready to register. But they are saying, that we are not cooperating. But we have written their letter. Kindly give us the time when I will go. Nothing has been done. And Lord, so far as my case is concerned, if your lordship kindly see the photographs, and the photographs annexed to my application can one.
So you want compassionate appointment for land loser
appointment
scheme.
and compensation. Compensation.
No, under the land loser scheme.
Land loser scheme.
Compensation, compassionate appointment.
Appointment.
as well as for compensation.
Yes, I'm deeply obliged to your lordship. And lordship, kindly see photographs annexed in the Milord the application. How they are, Milord, acting forcibly and illegally by using their Milord the payloader to demolish construction of the over the land. Kindly see the photographs. Now they are not coming with before your lordship. Knowing fully well the matter is pending.
behalf of the ECL, Shushanto Pal is coming. He's on his way.
He's coming.
Huh.
Pass over. Yes.
The copy of the report, Milord, to file করুন the report.
It's already
report
ready.
রিপোর্টটা দিয়ে দিন মিস্টার ব্যানার্জি। Yes.
Lordship, Lordship,
Yes. Call the next matter.
Lordship, item number 14, Lordship, kindly make it after vacation, Lordship.
14.
14.
14 after vacation করে দিন। Yes.
Mr. Trivedi has arrived, your lordship.
ওই তো মিস্টার দ্বিবেদী
Where is he?
এসছে তো। এসছে তো।
Yes, Mr. Trivedi.
I have just got the number of the
All right. Pass over. Yes, you can make
2
up.
minutes. 2 minutes. I'm just
Yes,
coming. Because Milord, from Mr. Nirotpal Chatterjee, I got the numbers. Now I am going to search and everybody, they have got the contact.
All right.
Within 2 minutes, Milord.
Yes.
36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 55, 56, 57, 58, 59, 60, 61, 65, 66, 68, 69, 70, 71, 25, 26, 27, 28, 29, 81, 82, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 105, 106, 107, 108, 109, 110, 111, 112, 113, 140, 150, 116, 117, 118, 119, 120, 121, 125, 126, 128, 129, 130, 131, 135, 136,
Private respondent.
139, 140, 141, 145, 146, 147, 148, 149, 150, 151,
Petitioner 153. Yet. আছেন না না 30 কার হয়ে পিটিশন তো আমি দীপেন রাউত তোমার হ্যাঁ তো তাহলে কপি দিয়ে দিতে হবে তখন রিপোর্ট করতে হবে আচ্ছা আপনার এক্সেপশন টাইপ করবেন
না ক্যান আছে না ক্যানটাকে প্রেস করেছি
হ্যাঁ তো অন দ্য পেয়ার করে দিন অন দ্য পেয়ার
Malad, item number 30.
Call the parts per matter. Yes.
Malad, I am filing the report on behalf of the ECL, Malad.
But Lord, I would request your lordship to Lord take out my application, Lord, can 1.
Can 1?
Yes. But I have already shown to your lordship, Lord, my copy. Your lordship has seen.
Yes, can 1.
Can 1. Kindly see. Kindly see the
disturbing or entering the land of the person in any manner whatsoever. Okay, so your land is sought to be acquired.
Yes.
What are the plots?
The plots, Lord, your lordship will find page 19.
19.
19 of the application.
These are the plots.
Yes. And I have written a letter of page 20 to the general manager. And I have annexed the, my lord, the deed also. And record of rights.
Yes,
And
what is
I have
your
lodged the
instruction?
complaint.
Instruction is
Page
the
37, page 37,
the
kindly
plot
see.
mentioned in the representation are not in the approval list of the respondent company. Judicial board has not accorded to the unit of the management for purchase of those land.
Oh, you have entered and demolished the construction. This is my
What is
question,
your
Lord, before your
instruction?
lord.
Have you entered these plots?
No, so far my instruction is not so. Therefore, your lordship kindly ask the state to file the report. State.
No. I
taking
restrain you. If
the
you do not do
responsibility
so,
of the state.
I restrain you from these plots, entering
yes.
into these plots.
My
What is
lord.
your instruction?
My instruction is that I am not utilizing.
Then I restrain you from utilizing that.
Deeply obliged to your lord.
Please take instructions, come back on Monday.
My lord.
If you have not utilized, I will restrain. So far as the other plots, what you have done, your report says,
yes,
with regard to this, he is not cooperating. What cooperation you need from him?
So far the land belongs to her daughter. We are ready to make the registration, but no response has been.
No, they have to attend your office. They have to attend your office.
Okay, attend to
When? Please give a date. Mr. Banerjee is ready and willing to attend your office on that date.
The letters dated
November 2020. Just have within the photo. Kindly see the photographs.
mention করেছে।
And I have made representation to the general manager. No response, nothing else. And God's lordship kindly see, Lord, the page 37. The police, Lord,
I will take specific instruction and come back on.
I have every faith to my learned friend.
And what do you say with regard to your report? You say that with regard to these plots, she is not cooperating.
My
please
daughter,
fix a
my
date,
daughter.
He will appear there.
Yes, I have already kindly give us a date.
Which date?
Yes.
Please inform
Daughter.
Mr. Banerjee the date. Please come on Monday with regard to these instructions.
Instead of Monday.
And what do you say the state is doing? You are not doing anything.
No, so far the acquisition is concerned, but it is a state. We are the requiring.
Not acquisition.
No, requiring body. According to you, you do not require these plots. The other plots, as in Can 1. Then I have to request the state.
State is also.
State has nothing to do over it. Because
Yes,
they have
where is
entered.
Mr. Trivedi?
They have entered.
Please ask him.
I'm come back on Tuesday, madam.
Tuesday.
লেটার গুলো না কবে ওনারা হিয়ারিং এ যদি যায় কবে ডেট ফিক্স করেছে
বলো না তুমি দাঁড়াও একটা রিপোর্ট আনতে বলছি এই দিদি
ধীরাজ
এই তোমাকে ধীরাজ
matter.
But now I have found a way.
You have found a way.
Yes, Milan. My senior friend, Mr. Nilotpal Chatterjee, all my friends, I have told them that any matter come, I'll revert back to you. They are instantly providing me the numbers of the exact people whom I have contacted. The person concerned.
In this matter also, effective party is the ECL. Now, with regard to the certain plots, ECL says yes, they are not cooperating. For that, they will take instructions. Mr. Banerjee has said.
They are not doing the registration.
So, registration, they will be fixing a date, that will be done. Now, with regard to other plots, a can has been filed. It has been alleged that the ECL is excavating from those plots.
Demolished.
And they have demolished certain structures. ECL says, no, we have not done anything.
We have not done.
It is the state who has done. Because they do not require that property. It's the state who has done. So now it falls.
No, not required. The report says we have already sent, but it is yet to be approved. No approved.
Right, please give a copy to Mr. Trivedi.
I will
so that
take
he
it.
can take
Yes,
instructions and come back.
আমাকে না নাম্বারটা দিয়ে দেবেন কাকে কন্টাক্ট
Tuesday or Wednesday? Tuesday?
Yes, Malad, Tuesday, my lord has kept other matters, my lord, there.
Tuesday will be your day.
No, my lord, before my lord.
Yes, you will be available.
Yes, my lord, I will.
Now.
My lord, I have to be, my lord,
Kindly
but I
rescind
think
the
so, my lord,
Business
next week.
Service Limited.
Tuesday, Mr.
Kindly
Banerjee,
rescind.
nothing will happen. Let them take
The status quo to be maintained, your lordship. Kindly.
Status quo is a very
Status quo to be maintained.
let him come back on Tuesday.
Yes, that's right. But kindly, otherwise we'll again
From November.
No, you have to come with further application. That's why, Miller.
Further application is not necessary. I'm keeping it on Tuesday. Ashun,
His Lordship,
look,
who is
he's afraid of you, Mr. Trivedi.
No, but I'm afraid now, people. What is happening is, yesterday I was in a matter before the Honorable Chief Justice Miller, We were saying that some people are saying we have not demolished it. And some nowadays, Millard, some unknown persons are coming and they are demolishing it and it is being blamed on the state. So this is a precarious situation.
happen, Mr.
They are precarious situation.
He stated the state
Precarious
has nothing to do,
situation.
state has no role to play.
Mr.
Only Eastern Coal
All
Fields
right,
have-
now, yes.
Be that as it may, Millard, we will take instruction.
Mr. Banerjee, if the Eastern Coalfields have said no, now it's the state has to
Yes,
look
Millard,
at it.
I shall.
Because if it is a question of acquisition,
Eventually
demolition,
come
state
with
has to.
report from the
Ma'am,
supervisor.
we shall.
Please give him a copy of the photographs also so that he can.
আমাকে
আমি দিয়ে দেবো, সব
দাদা আমাকে দিয়ে দিলেন
দিয়ে দেবো, আমাকে বলতে হবে।
আর ওই ভদ্রলোকদের অ্যাড্রেসটা মানে
Also do something, take one junior of you because it will be difficult for you alone to take. Please take any one of.
Yes, Millard, because my juniors for the last 4 years, they are not in any panel, but they are well trained with union matters because appearing in
But keep
and
take
what
one, otherwise you will be in difficult.
Yes, Millard, like here in my lord's court, I have community kept Sunil Gupta over here so that Millard, he can just tell me when to come, what not to come. Millard.
May I take back the photographs, Millard, so that
Yes, take it back. Please give a copy.
yes,
too.
yes.
Give a colored copy.
Yes.
Don't
Same.
give black and white.
Same. No blood, Article 14 will be attracted.
Yes, call the other matter.
I'm obliged to your lordship, and obliged to my learned friend.
Yes, have
My
you
lord,
given a
my
copy? Have you got a copy?
My lord, I have
Even
received
you
a
have taken
copy. I
instruction.
have sent a scanned copy to the concerned respondent number 3 now. Because, my lord, here, my lord, what I he has asked me
All
to.
right, let me hear her. I
Yes,
have
my
not.
lord. My lord will kindly hear.
Yes.
Because I also want certain details. What the allegation is, no specific details are given, my lord. Will kindly see.
Yes.
Your Lordship, I'm residing at the premises for over 80 years. Your Lordship, last on 12th May 2026, Your Lordship, officials of the BLRO has came at my place and said that the entire structure has to be demolished and that has to be demolished on.
On which plot? Please show any document that you have a right in respect of a plot. Please show me. You have
Your
not annexed any document.
Your Lordship, I have annexed my Aadhaar card to show.
Aadhaar card does not give you show which property you are the owner, your right.
Your Lordship,
Nothing.
I'm the possessor of that place, Your Lordship.
Please show me the document of possession. Merely by saying that you are in possession will not help.
Your Lordship, then kindly, Your Lordship, I'm praying for an ad interim order so
No,
that.
ad interim, madam,
Your
at the mere
Lordship.
asking, interim orders cannot be
Your
passed.
Lordship, kindly
You have
keep
to
it on
satisfy
Monday,
the
Your
court.
Lordship. I would
No.
satisfy Your Lordship.
No.
I'll come up with the electricity bills and
Come up
1,000
with
cards.
the electricity bills.
Lordship,
I will consider no. Interim order in that fashion, no, madam.
Your Lordship, I have all the original documents right now. अच्छा कि अपने का check हो. My Lord, kindly 2 minutes, Your Lordship.
What is your right in respect of the property?
Your Lordship, I have the adversary right of
Of the-
possession. I'm the adverse possessor of that place, Your Lordship.
Adverse possession against whom? You are claiming adverse possession against whom? If you
Your
claim
Lordship.
adverse possession, you have to admit someone's title. So, adverse possession against whom? Please
Your
show me your record of rights that you are in adverse
Your
possession.
Lordship, kindly give me some time, Your Lordship, because I have to collect all the papers, Your Lordship.
Madam, you must be having those adverse possession if you are claiming. You must be having. Please show me your
Your
record of
Lordship,
rights.
12th of May, they said, Your Lordship. 14th of May, I've stated to the police station, I have sent complaint.
Police
Your
station,
Lordship.
police in action. You go before the police in action court
Yes, Your
for
Lordship.
protection of your life
This
and
is-
property.
The police
On this
officer-
allegation, no materials. You have only implemented the block land and land reforms officer.
Your Lordship,
Nothing.
kindly see, Your Lordship, I have that possessory right. I have the Aadhaar card, ration card.
Aadhaar card is nothing.
Your Lordship, but
Aadhaar card
regarding-
does not give you any right to possess any property.
Your Lordship, kindly consider.
It's
Your
not a
Lordship-
document of possession either.
Your Lordship, kindly consider, Your Lordship, in order to show these documents, Your Lordship, I need certain time, Your Lordship.
No injunction. You can protect your possession.
Your
No
Lordship,
injunction.
one innocuous prayer, Your Lordship, kindly let them not to demolish
No.
without a proper notice, Your Lordship. They have not served me even a notice, Your Lordship.
Show me your right. Without any right, via an order of injunction. Cannot be at the mere asking.
Your Lordship, and even there is a ruling of Supreme Court, Your Lordship, that
Supreme Court, anyone can come. Please show me the Supreme Court
Your
decision.
Lordship, I don't
Please
have
show me.
I don't have the judgment right now, Your Lordship.
Madam, if you want to rely upon any Supreme Court judgment, you have to produce that.
Keep it on Monday, Your Lordship. I'd come ready with all the documents,
Yes,
Your
yes.
Lordship. Monday or Tuesday, Your Lordship.
Tuesday, Monday, according to your wish, but without any interim order.
Your Lordship.
Without any interim order, madam, I am making it specific.
Your Lordship, I'm showing the ration card and all
No,
because
ration card is nothing. Rather, ration card does not give you any right to possess.
some documents, but it is required to. So sorry, Your Lordship, it's not about the adversary right. It's about that his father has purchased the property in some earlier time, Your Lordship. I have the original one also.
অরিজিনালটা দিন ওইখানে একদমই দেখা কিছুই পড়া যাবে না এই অরিজিনাল ও ছেড়া আছে
একদম 62 সালে 1362
Which plot?
Your Lordship, plot number I'm stating plot number 1760, Your Lordship.
1760.
60.
My lord, they have stated in paragraph 3 of the petition. Paragraph 3, Lordship, page 3.
Your Lordship, LR plot number 1760, Gram and Moja Piplan, GL number 105. तो आगे बोलते हैं
What is your name?
Your Lordship, my name is
Suryakanto
Suryakanto
Koiborto.
Suryakanto Koiborto.
You are claiming through whom?
Through Nimai Koiborto. My father. আমার বাবা কিনেছে মানে আপনার বাবা কিনেছে
Yes, any civil suit between the parties?
No, Your Lordship. No, Your Lordship. কোনো সিভিল মামলা ফাইল
This property in the record of rights?
Your Lordship, that I have to take instruction, Your Lordship, because the condition of the paper is not.
আপনি একটা কাজ করুন মঙ্গলবার দিন আসুন আমরাও my instruction, my officers, I've just sent my officers are saying at least they need some time to understand because if my lord goes through the petition, my lord, nothing is there, my lord. Where is the title? Why? Who has come? Even it is apprehension that some persons, my lords, kindly come to page 4, paragraph 8.
It's a vague written complaint.
My lord, the one Aadhaar card, then they are saying that themselves, say paragraph 6. Inter alia on 12/5/2026, some unknown persons claimed themselves as officials of respondent number 2 came to the premises of the.
Not also made any representation to the BLRO.
Nothing.
The representation is before the
And
inspector in
no,
charge.
that representation has also.
Before the police in action bench.
Your Lordship, kindly let them come, Your Lordship. Kindly let them come.
No allegation, no representation even to the block land and land.
I didn't got time, Your Lordship, because they
only representation is before the.
That has also not been sent, my lord. They are saying
also not been sent.
No,
Your Lordship, we went to the police station, but the police is not entertaining.
It's not also signed.
Your Lordship,
it's not also signed.
Your Lordship, this is the another copy, Your Lordship.
Please,
my Lord, kindly give me some accommodation, Your Lordship, at least until Wednesday, Your Lordship.
The এটার লেখার দরকার নেই।
Lordship, I have
Otherwise,
sent the
Mr. Trivedi, that last line may be used in other way.
Your Lordship, I have sent the complaint through email also, Your Lordship.
That I
email
do not know anything.
I'm trying to
Only an
solve that
unsigned
first.
copy that is.
Your
Yeah,
Lordship,
এটা দিয়ে দিন।
সাপ্লিমেন্টারি সব দিয়ে দেবেন তো, আপনাকে তো লিভ
Wait, you can annex all this.
আমাকে কথাকে দিয়ে দেবেন, কথাকে।
Yes, Mr. Bhatt.
After the chance,
There's a division. There are two division benches after recess. Yes, because entire list has been called on, Mr. Panya. And there are two division benches from 2 p.m. Hardly any chance, and
3:30 also today. 3:30 also today, Lordship.
3:30.
Friday.
Thank you. Sorry for the delay. I was held up in the other bench. Yes.
This matter, your lordship was hearing, my lord, the maintainability of the appeal. I just cite one judgment on the issue your lordship is asking for, my lord, whether issuance of a rule is amounting to a punishment for the purpose of section 19. My lord. This is 1978, volume 2 SCC, my lord. Kindly see, my lord, first paragraph itself. This is an appeal filed by contemner under section from the order dated such and such of the High Court, directing issuance of notice to appellant to show cause why he should not be proceeded against for committing contempt of the High Court. Then paragraph 3, your lordship will see. Para 2, preliminary objection was raised by such and such, and that no appeal lies to this court under section from an order issuing notice, as nothing has yet been decided by the High Court. Then in paragraph 3, preliminary objection raised on behalf well founded must be accepted as correct. Then 19(1) is quoted. Thereafter, it would appear from a plain reading of the section that an appeal shall lie to this court as a matter of right from any order or decision of a bench of the High Court if the order has been made in the exercise of its jurisdiction to punish for. No appeal can lie as a matter of right from any kind of order made by the High Court in the proceeding for contempt. Proceeding is initiated under section 17 by issuance of a notice. Thereafter, there may be interlocutory orders passed in the proceeding by the High Court. It could not be the intention of the legislature to provide for an appeal to this High Court as a matter of right from each and every such order made by the High Court. Order or the decision must be such that it decides some bone of contention raised before the High Court affecting the right of the party aggrieved. Mere initiation of a proceeding for contempt by issuance of the notice on the prima facie view that the case is a fit one for drawing up proceeding does not decide any question. This court for the first time cannot be asked in such an appeal to decide whether the person proceeded against has committed contempt of the High Court or not. The matter has to be decided either finally or maybe even at an earlier stage. An order is passed which does not decide a contention raised by the alleged contemptor asking the High Court to drop the proceeding. It is neither possible nor advisable to make an exhaustive list of the types of orders which may be appealable under section 19. A final order surely will be appealable. Our attention was drawn by such and such to section 20. Then, my lord, he submitted that initiation of the proceeding by the High Court will be without jurisdiction if it is in violation of section 20. It may be so. If the alleged contemptor in response to the notice appears before the High Court and asks it to drop the proceeding on the ground of it being barred under section 20, but the High Court holds that the proceeding is not barred, it may well be that an appeal would lie to this High Court under section 19 from such an order, although the proceeding has remained pending in the High Court. We are not called upon to express our final opinion in regard to such an order, but we merely mention that this type of order, by way of an example, to show that even orders made at some intermediate stage in the proceeding may be appealable. In our considered judgment, an order merely initiating the proceeding without anything further does not decide anything against the alleged contemptor and cannot be appealed against as a matter of right under section 19. My lord, this is one judgment, my lord. Same view is also expressed in the Midnapur Cooperative Society matter. One particular paragraph reiterates this view. My lord, I do not know whether on the last occasion I gave, I had given Midnapur.
Midnapur, you have relied upon.
Just see one paragraph there.
2006-5.
Yes. 399. Paragraph 11 is the summary. Kindly come to paragraph 11, where they have summarized the position under paragraph 2 of that. neither an order declining to initiate proceedings for contempt, nor an order initiating proceedings for contempt, nor an order dropping the proceedings for contempt, nor an order acquitting or exonerating is appealable under 19. In special paragraph 11, Midnapur. So, my lord, here it says, nor an order initiating proceedings for contempt. This is also not appealable. Special circumstances, they may be open to challenge under Article 136. And for, my lord, completeness, a division bench of our court, my lord. Yes. 1998 SCC Online Cal 442. Yes. কোন জায়গাটা দেখেছো? Paragraph 18. Lordship has got it. MAT 760 of 97, MAT 606 of 97 were filed by the administrator against the orders dated such and such in terms whereof his appointment was suo motu contempt proceeding was initiated, special officer was appointed, administrator represented by such and such. Is admittedly no longer looking at, as indicated, he himself prayed that he may be relieved of his duties. He has therefore lost the locus to continue with this appeals to ventilate his. So far as this part, my lord, so far as initiation of suo motu contempt proceedings by the learned trial judge is concerned, evidently no appeal lies in relation thereto. In terms of section 19 of the Contempt of Court, an appeal lies only if an order has been passed by the judge of this court in exercise of his jurisdiction under the Contempts of Courts Act. Initiation of a contempt proceedings in exercise of the said jurisdiction is not an order which is appealable either under 19 of the Contempts of Court Act or clause 15 of the latest patent of this court.
by the order which is under appeal,
Yes.
is it a mere show cause notice?
It is an issuance of rule.
Yes.
It is an issuance of rule.
Issuance of rule with a definite finding in paragraph 44 of the order under challenge.
But if it is a rule
It's
issuance,
not a mere
no, my lord, I'll tell you, Lord.
issuance of a contempt jurisdiction or initiation of a proceeding.
My
There
submission
is a
is
specific finding that there's a violation. Only what
then,
punishment
my lord,
should
for
be
what purpose the rule will be issued? If a court has already come to a conclusion that there is a violation,
44 says that. What more?
no, my lord, even in
Paragraph 44.
I understand, my lord. Point is, my lord, your lordship will have to kindly see in any order, whenever your lordship, like it is like an interim order. Whatever findings your lordships give, because when your lordship comes to a primary finding part of an interim order, whether there will be an injunction or no injunction or receiver or no receiver at the interim stage, your lordship records the reasons.
There's a distinction.
And therefore,
that's a prima facie finding.
of course, but therefore this is also has to be
Here-
prima facie.
Here, this rule is there are two things: violation, specific finding. But what punishment should be imposed for that rule to give you, as in disciplinary proceedings matters.
No, but
A second show cause notice, Mr. Shen, please conceive of those situations.
Yes.
The disciplinary authority comes to a finding, charges are proved. This and these charges proved, this charges not proved, or all charges proved. Now a second show cause notice as to there are various grades of punishment.
But
So for what imposing punishment, a second show cause notice to give
Yes,
you an
but,
opportunity.
kindly
So
see,
is it not like that? After holding, what punishment for that rule to give you to
but
give a
the
reply
rule,
to
but
that?
the rule is only a show cause. Rule is to show cause, because after issuance of rule, the party will furnish their show cause. Why there should not be any punishment? And what is the ground for saying that there should not be any punishment? Their justification is the order is complied with.
You have the contempt of course rules of the High Court.
আছে তোমার কাছে?
Rules framed under the 71 Act.
You have a copy of that rule.
It's not there, but I am apprising on this. I am well acquainted with the rules. Firstly, a contempt petition has to be filed. Once it is filed on affidavit, there is no right of the alleged contemner on that day. If the learned judge finds prima facie violation of contempt, under Rule 19, he may issue a rule or may pass any other order. Then the alleged contemner comes and he files an affidavit. Now, what is the situation in that rule and what is the learned judge has done? That has to be distinguished. How many times the learned judge framed an opinion that there is violation, and what remains to be adjudicated in the contempt petition by a long, lengthy judgment finding it guilty, observation, and not saying it is prima facie. Absolute finding that he is guilty.
What further remains, Mr.
Yes,
Singh,
and that apart, my lord, I have
decided
that of my learned
on the rule.
That apart, my learned
Everything, both parties were heard.
Yes, yes.
On affidavits.
Yes.
On affidavits.
On affidavits. Compliance, no. It's a compliance report was filed.
Maybe. So
and
in
then exception filed. So on
whatever
affidavit.
form, in
Yes,
whatever form.
the affidavit.
So on affidavits of finding that there has been a violation. So after that rule, what remains?
Well, that apart, last occasion I have submitted, my learned friend is not answering. The learned single judge has issued rule of contempt for violation of his own order when it was modified by the division bench. Absolutely infructuous decision. And we have taken that plea in affidavit of compliance, this infructuous. My learned friend should answer that instead of going into the merit of the case.
I'm not going to merit. I'm saying that the appeal is not maintainable because an order.
Appeal is not maintainable, Mr. Shane. What remains thereafter? You have to decide on the facts.
Yes, yes.
Maybe at times you see that initially when a contempt application is filed, initially only a direction to serve is there.
Yes.
Service. One or two times they do not appear, then a rule is issued. That's on a prima facie finding. Nothing is, the other side is not appearing. There is nothing on record to show that there is no violation. Court issues a rule. Now, maybe at that stage, that order may not be said to be against that appeal lies. But here is a case. After the parties were heard at length, according to them, they have complied with, they filed an
But
affidavit
that
of
is
compliance.
yes.
According to you, no, it was not a compliance. You filed an exceptions. So affidavits either way.
Yes.
And an elaborate hearing on those affidavits. Thereafter, a reasoned order, a detailed order, holding that there is violation. What further remains to be decided on after issuance of a rule?
But I'll show my lord the order once.
Maybe because there was no formal issuance of the rule, in order to comply with those formalities, the rule was directed to be issued, only to complete those formalities.
But your lordship will kindly see, ultimately, my lord, then the language of the statute has to be given effect to. These observations which are there.
Language that has to be applied to the facts.
Yes. Number one, well,
It
my
says-
submission will be, well, whatever.
Which you are citing, which you had cited, please take up paragraph 18 you are citing, last portion of paragraph 18, which is after page 423. You have seen the 423 page. There is a dotted line after that. You have found that?
My lord, in Calcutta judgment.
Yes, 1998 SCC online cal.
Yes, yes.
482.
Yes.
Please come to paragraph 18, dotted lines, 423.
Yes, yes.
Please come to the first sentence,
Yes.
effective sentence. A judgment within the meaning of clause 15.
Postulates a final order, meaning thereby an order determining the rights of the obligations of the parties finally.
Yes, here it has been determined. What remains after a final adjudication being made that there is violation, that's only what is wanted in a contempt jurisdiction, whether there has been a violation or not. If violation, then the punishment. What punishment will be imposed?
But
So adjudication is there.
My submission, subject to correction, my lord, is that any finding in a judgment preceding resulting in an issuance of rule is only tentative. Otherwise, there is the requirement to issue, require them to give a show cause.
That is to be accepted, Mr. Shen. The entire proceeding was in violation of the rules. Could not have been done without issuance of a rule.
No, my lord.
Could not have been, those findings could not have, if your submission is to be accepted.
It is tentative. Otherwise, why the point is, why should court issue a rule?
The process, that is what for that I want to see the rules under the 1971 Contempt of Courts Act. Do you have the rules with you?
বার করতে পেরেছো?
Only with regard to the, only with.
পাচ্ছি না এটা খুঁজে পাচ্ছি না।
Lord, kindly see rule 19. When an application is filed and what is the power given under rule 19, 19.
Yes.
বের হচ্ছে না? না, rules চাই।
That is on presentation of a contempt petition. And the learned judge has done.
এটা না।
Hearing one after the other day and ultimately coming to the merit. And on that day issuing rule, not on the first day he issued rule. And that too after the modification of the order by division bench.
So rule can be issued first day itself.
Yes.
But that your lordships do not do. Your lordship gives them a notice to show cause.
That is what I am saying. If the court is prima facie after getting what is being done, now we are repeated orders are passed. Don't issue a rule on the very first day.
Yes.
Serve, but the rule says otherwise.
Yes.
Rule says otherwise. So when a contempt application comes up, after hearing the petitioner, So the court finds, takes a prima facie view that whether yes, some sort of violation is there or not. If the court finds no, there is no violation, immediately summarily the court can dismiss it.
Yes.
Then, if the court decides not to dismiss, has to issue a rule.
But what is done?
No, so that's the procedure.
Yes.
So why? So when after the rule is issued, then the parties will come after hearing then decision. It's the procedure which is being followed is not that contemplated under the rules. Now here the parties are heard at length.
Parties are heard.
Comes to a finding. Then only issuance of a rule is only to complete the formalities. Because it says punishment cannot be imposed without issuance of a rule.
But even then,
finding is
but
there only.
even then, my lord, I come here, my lord, even then, if that is also the procedure, even then, my lord, if the observations are there that there is a violation, but you still rule is being issued to show cause. So where is the, unless punishment is there or a decision on the merits of the matter? There is no decision on the merits of the matter. There is but the contempt jurisdiction is like that. I have the court has the jurisdiction only to punish. If punishment is given, appealable. If punishment is not given, but still court pronounces upon the merits of the principal order, which is affecting the rights of the contemner, then it is appealable. But here, what has happened? The court has expressed an opinion that the compliance report which you have filed does not amount to implementation of that order. Therefore, I am issuing a rule. So, my lord, where is it affecting the merits of the matter? There is no pronouncement on the merits of the matter. In all other cases which your lordship will see where an appeal has been entertained as a clause 15 appeal, there was some other incidental direction passed by the contempt court which was affecting the rights of the contemner. Here, my lord, the court has only concentrated on the compliance report, exception to the compliance report, whether the compliance report is correct or not. Prima facie finding compliance report is not correct.
Pausing here for only one thing. This investigation can be done at what stage?
This investigation can be done.
Whether it can be done pre-issuance of a rule. Please show us from the contempt of court rules whether this investigation.
But that is done in all the matters that is being done.
That is
so, that is so a practice can evolve, a procedure can evolve by
technicality now for
Yes.
issuance of a rule. So now you cannot say yes only by after the issuance of a rule. It's all findings have been made only to complete those formalities. Formal issuance of a rule has been directed.
Well, I cannot improve upon what is there in the order, but my submission is to this
Because
extent.
this
But
judgment which you have said, you have cited that 1998 says that mere issuance of a rule. We have noted that that is what.
Not only mere, it goes on both. Even a notice has been issued that which is a rule. Rule is nothing but a notice calling upon you to show cause.
But so it's only troubling that all findings have been made prior to that.
So these these findings have to be read as tentative. Like an injunction order. Your lordship will go to an injunction order without a finding. There cannot be any injunction order. There has to be a findings on
Even
three
against
tests.
that, Mr. Shane, appeal lies.
Yes, my lord.
Even against an ad interim order, appeal lies.
Yes.
As per the statute.
I am
As
not
per
on
the
that. I am
statute.
only on the what
So
is the
that
effect of
also
a
in
fine.
prima facie, it affects right.
No, but here, my lord, this is a special act.
That is what.
That is, my lord, this is a special act. Interpretation has been done. Yes, my lord. So, my lord, to this extent, these are my
So
sub.
according to you, mere issuance of a rule against that,
And these
appeal
whatever
does not lie.
appeal does not lie. Whatever findings are there,
A
these,
prima facie.
these are all prima facie findings. These are not it is not that the court cannot have a relook at the matter upon the explanation coming by way of a rule. So, my lord, so therefore, no right of the parties is decided here. And regards, my lord, their submission that the order was without jurisdiction. That submission I have already made. I just summarize it, my lord. It is not a case of complete inherent lack of jurisdiction, because the Supreme Court says that rule of merger does not follow from any statute or a constitutional doctrine. It is a practice which has evolved on the basis of hierarchy of courts and hierarchy of judicial decisions. So this is a case, therefore, at the most it can be said that it is an irregular order, not an order lacking in inherent jurisdiction, and it is therefore, when a party has, despite taking a stand that doctrine of merger applies, but a compliance report has been filed and a compliance report has been gone into by the court, and there is a prima facie view, so therefore it is not a case of inherent lack of jurisdiction. It is a case of parties ultimately acquiescing to the jurisdiction despite reserving a stand. I am not saying that they have completely forgone that stand, but a compliance report was filed. Not once, but twice.
Compliance report to show
that
if at a stage the appeal court has modified the order of the trial court, after that a compliance report is filed before the trial court. Let us take it in that way. So saying that we have complied with the order of the appeal court.
Yes.
So by that, does it mean that the alleged contemner has accepted the jurisdiction, or it's the contemner who is trying to show the court that yes, look, none of the court's order have been violated, or the final order has not been violated, only to show the bona fide. So whether by that, merely by filing an affidavit showing that yes, we have complied with the order, does it mean that yes, he has subjected to the jurisdiction?
Well, it is a case of acceptance of the jurisdiction, because I am submitting a compliance report that the order, as it modified, as it stands today,
has been modified as it stands
today, has been complied with. I am taking a stand that it has been complied with, and thereupon, well, the court has decided that court does not find compliance. Court says I'll issue a rule. This is the position, my lord. These are my submissions, my lord.
Yes. That has not answered the question.
And well, just lastly, don't take it that this is my final submission. This is the last alternative submission. The division bench has the power, my lord, to transfer the records of the contempt proceeding to itself, see for itself the compliance, and take necessary action.
I am opposing that. Rules specifically provide some procedures. It cannot
That
be
is
transmitted.
that is up to the court. Because my lord, we are in a case at a stage. It is like a stage of execution and compliance.
Yes. In apropos to your submission of this, you have filed a contempt application before the single bench, alleging that the order of the single bench has been violated.
At that point of time, there was no order of the appellate court.
Yes. So order of the single bench was violated. So that was the violation which was alleged before the single bench. Now the division bench cannot test that. Division bench in contempt has to test whether the order of the division bench was flouted or not.
Yes.
So it's a different thing. It cannot take up that. It cannot decide whether the single bench order was violated. So it's a different thing. If you have to file a fresh application for contempt or whatever transferring may be a difficulty because pleadings and other things.
No, records are all there.
Records were-
Compliance report is being shown of the order of the division
Your
bench.
case was that in the contempt application, violation of the single bench, not of the division bench. Violation of the single bench. But so it will take a different character altogether. So that is a different.
I think by supplement,
transferring may be a difficulty. By way
I
of
leave it to
transfer,
your lordship,
because
but procedures are handmaid of justice. The entire rigmarole has to be gone into, but the justice will not be done because it will take that.
Ordinary transfer is a different thing altogether.
Your lordship
But
is
here
sitting
is
in
a
a
case-
division bench of
you have
your
to amend-
lordship's
you have
order.
to
Your
amend that application also.
Yes, my lord.
You also have to amend that application. It's
There
not
is
that-
already supplementary affidavit is there bringing on record the division bench
That is
order.
what I'm telling you. So on that, it cannot be decided.
That I leave it to your lordship, my lord. I will not waste your lordship's time on that, my lord.
Yes.
It is entirely up to your
From the
lordship.
first submission, supplementary evidence. This honorable court has deprecated the very basis idea of filing supplementary affidavit. Division bench
But
judgment is there.
regularly, the order prayer is being made to file a
No,
supplementary
the
affidavit.
division bench judgment I have gone through.
Yes, yes. We are aware of
Aware.
those judgments.
It has to be
but
done
regular-
by application for amendment. Application
That
for
should
amendment.
have been. That should have
Yes.
been the thing. But nowadays, the supplementary
Supplementary
affidavits are
affidavit.
filed.
But how can the prayer be amended by
That
supplementary
is
affidavit?
also done by way of supplementary affidavit. Pleadings, grounds, as
Everything,
well as the
everything,
prayer.
everything. Now comes the moot question, my lord, that he has raised whether transferring the matter to division bench. Your lordships were asking about the rules. Rules prescribe a specific procedure. Application has to be filed. Prima facie opinion has to be formed by the division bench and then issue of notice. Now, my lord, I had the privilege to get a stay from the earlier division bench. Their lordships twice requested Mr. Sen, what prevents you from filing a contempt application before us? Even thereafter, he proceeded with this before the single bench.
Yes, because
Document
according
already
to
ordered,
Mr. Sen, his right to proceed with the contempt it still remains. That's his.
Yes, now
he has
I'm
taken a chance.
now I'm
That
answering.
stage, the order was already passed.
Yes.
I'm
when we were in
I'm answering that. Now, what is the contempt he has asked for? Violation. My lords are aware what is the definition of contempt. Willful and deliberate violation of the order, and it is going on continuously, willful and deliberate violation. Contumacious and deliberate. Now, is there any whisper of willful and deliberate violation of the order passed by the learned single bench in view of the modification? Nothing remains. Where from the learned single judge assumed jurisdiction? I shall show to your lordship from the repeated orders passed by the learned single judge that it was brought to his lordship notice the division bench has modified the order. Even thereafter, he continued, asked us to file contempt compliance report. We filed compliance report, brought it to his lordship notice that this has become infructuous contempt application. And even then, what has rightly fallen from my lords, the judgment which issuing a rule of contempt is an elaborate judgment. And I am showing to your lordship what are the pages where your lordship will kindly find the learned judge has decided the contempt. This has rightly fallen from your lordship, apart from para 44.
50 also.
50 also. Therefore, what remains, it has rightly fallen from my lords, that rule has been issued only to punish for contempt. Nothing remains after two exchange of affidavits. And the question of doctrine of merger, it is well settled that if an order which is modified by the division bench, whether the order passed by the learned single judge remains. It does not remain on record. It is modified. So whether we have, if we say we have complied with that, with certain defense, whether this is a separate cause of action to challenge the decision-making process by us, by a separate writ petition, or whether any contempt survives. That is also the other point. Now comes, I was submitting on the last occasion that apart from clause 15, there is the distinction is made by the Supreme Court that Order 43 Rule 1 and a comparative study between Order 43 Rule 1, CPC, Read Section 104 and the clause 15. Supreme Court has said Order 40, the rule 1 has rightly fallen from my lords, has a wider power to entertain an appeal read with section 104. And clause 15 has been defined even in Midnapur's cooperative societies he has relied upon. He has not read out the entire paragraphs. There also it has been held that yes, under clause 15 appeal lies. I am drawing your lordship's attention to first to that.
I accept clause 15 lines.
Yes.
Really like.
Please don't make running commentary. While you are arguing, I have not said anything. Kindly come first to page para 7 of the Midnapur case. He has relied on.
Yes, Midnapur.
Para 7. Para 7, my lord, I am feeling aggrieved, respondent number 1 and 4 in the contempt petition, such and such. A division bench of the High Court dismissed the said appeal as not maintainable by impugned judgment dated such and such. Then Roman I, the order of the London Single Judge did not punish any contemptor. Therefore, the appeal could not be entertained under section 19 of the Contempt of Court Act 1971, which provided for appeals only against the orders punishing a contempt. The appeal did not satisfy the requirements of clause 15 of the latest patent and therefore could not be entertained as a latest patent appeal. While so dismissing the appeal, the division may direct the appellants that into forthwith implement the order of the London Single Judge. The said judgment is challenged in the civil appeal number such and such. This court, while granting leave on such and such, state the operation of the order. Then para 8, kindly skip over and kindly come to para 11. Before that, para 9. Para 9. Para 9 will kindly come at page 407. On the aforesaid facts and consideration, the following questions arise for consideration. Whether the High Court in a contempt proceeding renders a decision on the merits of a dispute between the parties either by an interlocutory order or final judgment. That is exactly our case. Whether it is applicable under section 19 of the Contempt of Court Act 1971, if not, what is the remedy of the person aggrieved? Then 2, where such a decision on merit is rendered by an interlocutory order of a London Single Judge, whether an intercourt appeal is available under clause 15 of the latest patent. In a contempt proceeding initiated by a delinquent employee against the inquiry officer, as was the chairman of the secretary in charge of the employee bank, complaining of disobedience of an order.
This cannot be relevant.
This is not relevant. Then kindly come to the point number 1, para 10. Section 19 of the Contempt of Court Act 1971 provides for appeals. 11 portion of this is we all know. Then kindly come to para 11. Para 11. Next para. 411, page 411. 5.
Yes.
Roman 5. No, not Roman 5 also. From earlier. In a proceeding for contempt, Roman 3, the High Court can decide whether any contempt of court has committed, and if so, what should be the punishment and matters as incidental thereto. In such a proceeding, it is not appropriate to adjudicate or decide any issue relating to the merits of the dispute between the parties. Any direction issued or decision made by the High Court on the merits of a dispute between the parties will not be in the exercise of jurisdiction to punish for contempt and therefore not applicable under section 19 of the Contempt of Court Act. The only exception is whether such direction or decision is incidental or an inextricably connected with the order punishing for contempt, in which event the appeal under section 19 of the Act can also encompass the incidental or inextricably connected directions. Now kindly appreciate what has happened. Kindly appreciate what has happened here. The London Single Judge passed an order. Appeal was preferred, modified, admittedly. Yes, contempt was filed before modification. But after modification, these orders I'll be placing, time and again it was brought to his lordship's notice, which has been modified. But his lordship went on. Wanted us to file compliance report. So what compliance report shall we file? Compliance report of the London Single Judge's order or the division bench order? And the London Judge has no jurisdiction to take up the issue as rightly fallen from your lordship of the division bench violation. It is without jurisdiction, totally, which he has done. Totally without jurisdiction. Kindly come to 5, clause 5. If the High Court, for whatsoever reason, decides an issue or makes some direction relating to the merits of the dispute between the parties in a contempt proceeding, the aggrieved person is not without remedy. Such an order is open to challenge in an intercourt appeal if the order was of a London Single Judge and there is a provision for an intercourt appeal or by seeking special deputation. This is exactly we have done intercourt appeal. He has decided the issue and we are protected both ways. both under section 19 of the Contempt of Court Act, because the learned judge has decided the issue. What is left open is to punish for contempt. Rule is issued after detailed judgment holding it that we have committed contempt. And that too, assuming a jurisdiction of the order of the division bench. And rule has been issued, your lordship's attention was drawn on the violation of the learned single judge's order that no longer exists. Kindly come to page 129 of the stay application.
As modified.
Oh, Judge sir shouldn't be. Page 129, minute of the my stay application. What is the order? 4th October 2024. Yes. Upon reading a petition of the petitioner and another and the affidavit of verification thereof dated August 23rd, 2023, and the exhibits annexes such and such, it is ordered that a rule to issue calling upon Rajesh Kumar Kaushal to show cause as to why he should not be committed to prison or otherwise penalized or dealt with or having fully and deliberately violated the order dated 11 April 11, 2023. The rule is simpliciter limited to his lordship's own order, which is no longer exists. It's absolute nullity. The entire proceeding is a nullity. Now that about assuming jurisdiction of the division bench, rule itself is a nullity. Then kindly come our stand in the affidavit of compliance. 131. 132 paragraph 4. The present contempt application has been filed for alleged violation of the order dated 11th April 2023. For that purpose, the rule was issued. And on about August 23, 2023, after the order passed by the Honorable Single Judge, on 11th April 23, the Honorable Division Bench modified the order dated such and such, and by an order dated 15th April 24. Accordingly, it is respectfully submitted that the present contempt application has become infructuous. It is not that we have submitted before his jurisdiction. We have time and again drawn the attention of the learned judge, single judge, that the division bench has modified, that is, your order has become infructuous. Even then, it went on. This is absolutely a vindictive way of punishing a person, and in that observation will clearly show that he has decided the matter. Is it a decision, my lord, on the merits of the case? The learned single judge's decision? If he is prima facie, I have said Rule 19 was satisfied, he could have issued a rule on the very first day. But went on, and then ultimately by a retail judgment issued, holding us a contempt, liable for contempt, issued a rule, what remains to be adjudicated. Therefore, it is, if that decision is taken, it is a decision which is punishing for contempt, applicable under 19 as well. Section 19 of the Contempt of Court Act. And about the latest patent, Section 19, blood. আস্তে। As modified and marked. There cannot be merger with the single judge as well.
Yes.
Yes. Now, my lord.
Yes.
Now, my lord, from page 100 of our stay application.
100.
Yes, till the order issuing rule of contempt by 50 paragraphs judgment, we have brought it to the notice of the learned judge about the modification of the order by the division bench. Even then, his lordship went on. And went on, not only went on, and in the observation, what his lordship has said, দেখি কোন paragraph গুলো বলছি? Paragraph 34, kindly come to paragraph 34 of the input judgment under appeal.
Page 124.
Before that, paragraph 33, it is also important.
What happened? There was a long delay in between the moving the appeal court and the order passed. What angered the honorable single judge?
I do not know.
No, that was no.
There might be some delay that you are delaying.
No, immediately, no, dates are relevant. The application for contempt was filed. Application for contempt was filed on.
Might be the honorable single judge was of the view that you are trying to circumvent the order.
Yes.
Taking
Yes.
pleas of that have moved, not
That,
effectively
yes,
moving the matter before
that
the
observation has also been made in the input judgment. I shall draw your loss.
There must be some reason why.
But what
On the
actually,
merits of the compliance report. Nothing else.
my lord, the details of the orders will show that we have brought it to the notice of the learned single judge in a contempt proceeding, that your lordship's order is no longer existing, it has been modified. Now, in the impugned order, when the rule of contempt was issued, kindly come to para 33 at page 123. 123 of the stay application.
Yes.
Although, has your lordship got it towards the bottom, para 33, para 33.
Yes, although
the division bench was of the opinion that the guidelines formulated by the directorate are merely illustrative in nature, and what the alleged contemptor has now done is to introduce clause 4.10.1 instead of offending clause 27.2, thereby mandating the NIT approving authorities use of the expression shall in clause 4.10.1 is to be noted in this context to keep in view the guidelines issued by the directorate as reflected in the office memorandum dated such and such, paragraph such and such, which again reintroduces what was specifically deprecated and sung by the Ministry of Steel and Government of India at time and agent. Where from London single judge assumed the jurisdiction to decide on this and make this observation? Well, although it was drawn to the lordship's notice, although division bench was of the opinion, as if he is assuming the jurisdiction of the division bench, so omnipotent, with great respect to the learned single judge, then kindly come to the next paragraph. This court, para 34, and the division bench, while modifying the order of this court, clearly directed the CPWD to modify clause 727.2 and not in thin air, but in consonance with the notifications issued by the Ministry of Steel, Government of India. We have exactly done this, and this is a separate cause of action. To move another writ petition, how does the contempt lie? And then para 35, 36. Does what the CPWD could not do directly has been done by it indirectly and in an oblique and surreptitious manner. What remains to be adjudicated? This is a decision and it's a judgment applicable both under section 19 of the Contempt of Court Act and under the latest patent. Then kindly come to the next. Para 39. 37.
Disobedience of both the orders.
Both the orders. So, which is no longer existing. And then below para 39. There is no carelessness or thoughtfulness or negligence or inadvertence in the said act. Rather, the act is in deliberate disobedience of the order of this court as modified by the division bench and thus contumacious. I do not know what is the meaning of this paragraph. Kindly go through it once again. Para 39. There is no carelessness or thoughtfulness or negligence or inadvertence in the said act. That is our act. Rather, the act is in deliberate disobedience. What is the meaning? It itself is in contradiction. Finding. Then sentence is in contradiction. Then kindly come to paragraph 44. Your lordship has gone through it. I am not repeating. 46, 43, 43 also. It is expected that in a country like India, the top brass of the CPWD is manned with sufficiently educated and intelligent people having sufficient qualification to understand the purport of a clear order of a division bench of this court to the effect that a particular clause was directed to be amended in consonance with the notifications of the Ministry of Steel. There was no ambiguity in such direction, which was explicit and self-evident. His lordship himself recorded the division bench order, the finding of the division bench. Then why did he continue with this? Para 43. With great respect, may I submit, I had the privilege to go through certain judgments of the Supreme Court. Supreme Court said about us, the lawyers, 2010 and 11 Supreme Court STC, that the court issuing rule of contempt against lawyers is shall be very much restricted. If a lawyer misbehaves and does anything, that shall be referred to the bar council. But a contempt is also available against the judge. So we are not going to that extent that the learned judge has flouted the order of the division bench and contempt was available against him also. This is my submission. Now kindly come to page 44. Your lordship has gone 46. Para 46. Just as the courts ought to circumstance. 47. As such, a clear message should go to violators that an order of a court is not passed by an individual but is exercise of the sovereignty of the country itself to the medium of the court and ought to be obeyed as sacrosanct. What remains to be adjudicated? Is it prima facie observation? Purely decision-making process? Then paragraph 49. Such being the case of the present instance, I do not find any reason not to issue a rule of contempt to the alleged contemptor. Accordingly, a rule to issue calling upon the alleged contemptor, division bench of the order of this court, as modified by the margin of division bench. This is also without jurisdiction. Para 50, the concluding part of the issuing rule is also without jurisdiction. Accordingly, a rule to issue calling upon the alleged contemptor to show cause as to why penal action as pled for in the contempt application shall not be taken against him for willful and deliberate violation of the order of this court as modified by the march and the order of the division bench as indicated above. This is unheard of. He is issuing a rule of contempt for modification of the order of the division bench. And that too on a date, I have drawn lordship's attention as page 1, issuing rule of contempt on a 120, 129. Clearly, it is 4th October 2024. Therefore, these rule
November 29, 2024.
129, page 129, the stay application.
Yes.
Order of 4th October 24, learned single judge issuing a rule of contempt for violation of his lordship's order of August 23. This is no longer exists. Violation of his order dated April 11, 2023. Division bench order কবে হলো? 15 Therefore, this is also infructuous. Not only jurisdictional error, it's a nullity.
Yes.
Now, the judgment my learned friend has cited, there in Mindapur's case, the 78 Supreme Court was considered. 1978 Supreme Court was considered and the conclusion was taken. Now, my lord, the doctrine of merger of the special bench judge. There, 2023 SCC online, Calcutta 1152. There, their lordships had been pleased to hold that once in a contempt proceeding also an order is modified or set aside by the higher forum, contempt lies before the higher forum because the doctrine of merger applies. This is a judgment.
This is the distinction with the execution as in a civil procedure
Yes.
court. In a civil procedure court, always the execution case has to be filed before the court of the lowest grade. Trial.
For execution of the higher court's order.
Yes. That's the distinction.
That's the distinction. That's true. If that is also taken into consideration, the learned judge ought to have taken into consideration not implementation of his lordship's own order,
but the
but of
division
the
bench's
division.
order. But as per the contempt of court's rules, it has to be before the division bench.
Before the division bench. Now, this say I need not trouble your lordship about the special bench judgment about doctrine of merger. Your lordships are aware of this. Detailed findings are given. Detailed clarification has been made. Now, I want to draw your lordship's attention to the Supreme Court finding. It's a very important 1981 Volume 4 SCC page 8. The corresponding 1981 SCC online Supreme Court 315.
1981.
A judgment is out.
That judgment, I think Mr. Sen has not cited.
No,
Oh, you are citing
I am
that?
I am citing.
Oh, I thought you are distinguishing Mr. Sen's judgment.
কপি থাকলে দিয়ে দাও কি আছে আমি শেষ করে দেবো না আর অন্যদিন হবে না Milord, there a clear distinction has been made under section between 100 section 104 related with order 43 rule 1 and
on clause 15
clause
against which
15,
orders
yes,
appeal lies.
Yes. Not only clause 15. The Supreme Court says order 43 rule 1 is a power is wider. Order 43 rule 1's power is not cartel.
Yes, show us that.
Milord, I'm referring to paragraph 21. First, kindly count to 21 onwards. Referring to 21, 26, 28, 33, 62, 47, 62, 70, and 78.
Please give us the paragraph 21, then
Paragraph 21, 26, 28, 33, 62, sorry, 47, 62, 70, 78, and the concluding part.
113, 119, 120,
113, para 113,
119,
119,
120,
120,
144.
144.
100?
144.
144.
Yes.
144.
This, let us come back next day.
How much time you will take?
So many paragraphs.
10 minutes, 10 minutes.
Otherwise, it's difficult to break. You have any difficulty, Mr. Sen?
I have.
Yes.
No, the view, I am not troubling your lordships. Your lordship will go through it. We have handed over the judgments. The view taken up by the Supreme Court is a distinction between Order 43 Rule 1, 104 And
Show us that.
possibly that case.
My junior my arbitration.
Finally come to page para 120. Thus, these are some of the principles which might guide a division bench.
But I can take a 5 minutes reply on the next day.
5 minutes reply on the next day. Then it's better to have it on another day. Then it's better because Mr. Sen will have to
5 minutes, I will not take much time.
So before vacation, is it possible? Of course.
আর বিকল বেরোবেন কখন সময়? Yes, only 5 more days next week.
5 more days, it's difficult. It has to be after the.
Very,
Uh,
first Friday after reopening,
it's 12th.
12th. Yes.
12th June.
Mr. Shane
Oblige.
the contempt of us.
No, it's